I am interested in historical trials, and this trial happened to feature one of the most famous defense attorneys, George Vanderveer, in the history of the state, who represented Thomas Tracy and the IWW defendants. I call this a tale of two trials because really every trial that has some social significance is a tale of two trials. It has to do with the movement that brought the trial about and the individual at issue. So I'm going to talk about that, but I want to tell you a little bit about how a trial lawyer would view that. George Vanderveer, at the time of this, and I'm going to go into this in some detail, was not any kind of a social activist. He was a lawyer who had been the elected prosecutor of King County. He had gone to Stanford and Columbia and made his way out to Seattle. He represented corporations with Judge Thomas Burke for a while, and slowly got involved as a defense attorney after his stint as a prosecutor, where he represented some of the famous bootleggers in Seattle's history. At the time when he saw the Everett Massacre trial, Judge Donworth had been written to by the IWW asking who would be a good defense lawyer to represent them. And he said George Vanderveer was the best defense attorney in the state. And Vanderveer saw this trial as a way of enhancing his reputation, making him potentially nationally famous. And his biography, which is a great biography, Counsel for the Damned, talks about this when he had a conversation with his wife. And he was telling her, you know, it's just a bunch of men charged with first-degree murder. It's nothing more, nothing less than a murder trial. You can tell this man's tried a few murder trials in his life. And then he came back to his wife after a meeting with Thomas Tracy and others in jail, and he said, I don't understand these men. They're like a bunch of damned religious fanatics. Even the men in jail don't seem particularly interested in saving their necks. They're more interested in standing up in court and expounding their ideas. Well, George Vanderveer was in for an education, and something that this trial actually changed the course of his life. Excuse me 1 second. How many of you saw the documentary, which I have not seen? A number of you saw the documentary, all right. Well, I don't want to go into in great detail about the facts, but I've got to tell you a little bit about it to get you into the trial. As you know, this occurred in Everett, which was a mill town. Some would argue an extension of the lumber camps around the mountains, controlled by the mill owners. And a major friction point at the time was the commercial club, which was owned by, or essentially run by the mill owners, and the business owners and their allies on the one hand, and the unions, which were not really together at that point. There were craft unions that had differences, and the IWW came up and tried to organize the shingle workers. They've been organizing for some time. They've become famous in Spokane in 1909. They packed the jails in a free speech fight, and they were to become famous in a number of places, including other places in the state. So Everett was heavily unionized. There more and more speakers were brought in for soapbox oratory, the social networks of that time, no longer not Facebook and not Instagram or whatever you use, but soapboxes on Hewitt Avenue. And there became a huge fight when the IWW came and spoke. The Salvation Army was allowed to speak in certain locations. The IWW was not. It was shut down for basically political reasons. Again, I'm really kind of cutting to the chase here. Ordinance 1746 was passed by the Everett City Council, limiting speech to particular locations. On October 30th of 1916 was the Beverly Park incident. A number of Wobblies came up to protest the ordinance. They were taken to Beverly Park and they were beaten. They were forced to run through a gauntlet. There were broken bones, they were beaten bloody, and the members of the commercial club were the organizing force behind that. And this sharpened their resolve for their side and for the commercial club side. And so, as you all know, on November 5th, about 300 Wobblies went on the Verona and the Calista. Now, the mayor of Seattle allowed them to march through the streets. But before that, I just want to mention, and I'm going to show you this later, this was the telegram sent by the Free Speech Committee, the Western Union Telegram, to Yakima. Wanted 2,000 men for Everett immediately. Come prepared for action. Every available member start at once for Seattle. Street meeting will be held in Everett Sunday, 2 o'clock, November 5th. Local arranged protest meetings. Collect funds. This fight must be won. All fighting members answered this call to action. And then you got a number of people, obviously, who answered that call. The IWW did more than that. They called members of the press. They had ministers publicizing the meetings. This was not a secret meeting. There were many, many people who were coming. So Hiram Gill, much to the consternation of some of the powers that be in Seattle, allowed them to march to the Verona and the Callista. A few were armed. And they then went up to Everett, and as you know, the Verona landed. Now, I know many of you have seen the documentary. For purposes of the trial, it's important for you to understand what a small space this is and where all the boat was located and the rest of it. And I'll discuss that in a moment. These are the pictures. You've probably seen them on the documentary. This is the Verona as a reenactment. The Verona is here. So Sheriff McCrae is standing no more than 6 feet from the boat when he first speaks to the Verona. And with him are Curtis and Jefferson Beard, the two deputy sheriffs. The men who are there, about 200 men who are mostly armed, are inside these buildings when the Verona first pulls up. And then the men start streaming out, and you can see what a small space this is. They're landing. So as you probably know, the sheriff called out, "Who's your leader?" And they yelled, "We all are." And then the sheriff said, "Well, you can't land here." They'd already landed, and the bow line had been pulled. It had already been docked. So, and they yelled, "The hell we can't." And somewhere there was a shot, and there's a controversy at the time. Was the sheriff's hand on his gun? Was his left hand up, his right hand, both hands? Once that shot was heard, about 200 at least shots were fired in this closed space with the Verona. And that's only the ones they could find. I can tell you from experience, having worked on a number of homicide cases, there are many other bullets that probably were never seen that just skipped across the water and went out to sea. Many people were firing blindly. They testified during the trial. They weren't even looking where they were firing. They're just firing into the ship. There were some shots coming from the ship. As you probably know, again, there was a tug out there that was firing. A guy had a rifle firing from a tug. And there was a dock across from the Verona, which you can kind of see back there, where there were people firing from the dock. The ship, the captain of the boat kind of hid, and the engineer, who was down below, threw it into reverse. And so the Verona did not end up looking like that, but rather perpendicular to that angle, going backwards, but held with the bow line, and it couldn't get away. This is important because I'm going to talk about testimony where Thomas Tracy is allegedly seen shooting out of one of these windows here. And there'll be a lot of questions about whether or not anyone could actually see these windows as the boat is pulling backwards. Finally, somebody comes out with an axe. They may or may not have cut the line, or the line may have slipped off, and the Verona goes out, and as you know, many men are dead. During the time when the Verona was being shot at, again, you've probably seen this from the documentary, the boat almost capsized because everyone ran to that side of the boat. Hugo Gerlach was up on this mast right here, and he was shot to death, slid down the mast, and fell off onto the deck. There were so many people on the boat, it was attempting to capsize, and the railings actually did break, and a number of people fell into the Puget Sound. And nobody really knows how many dead there were, because the reality is many of them showed up for action and didn't really sign in or leave their name. There were 5 IWW cars that were not claimed after the Everett Massacre, but there are probably many more bodies in the Sound. So they go back to Seattle. 74 men are arrested. Hiram Gill, the mayor of Seattle, actually denounces the Everett sheriff and his group, calls them cowards. So the state decides to proceed rather rapidly. This was the headline in the Everett Herald. And Thomas Tracy on the left and Jefferson Beard on the right. Charles Curtis was also killed. He was actually much more well-known. He had been involved in the National Guard, was a well-known figure, but early on it was determined the state couldn't proceed with his prosecution, or the prosecution of his murder, because it became, if not clear, questionable as whether or not he had been shot to death by his own men. So probably shot in the back. So the trial was solely about the murder of Jefferson Beard. The next day, so this huge event occurs, and a jury is convened, a coroner's jury almost immediately is convened, and that's when the murder charges are, again, the courtroom where this trial occurred no longer exists. The fourth floor of the King County Courthouse has been turned over to administrative buildings. This is actually a very famous case. Have you ever read Big Trouble? Great book about the 1906 murder trial for Mr. Haywood for the killing of Frank Sternberg, who was the governor of Idaho at the time. He was dynamited to death when he opened his front gate. Anyway, this is just to give you some sense of how packed in these trials were in those days. So here's the charging document. Snohomish County charged and put Thomas Tracy on trial first. While it's not entirely clear why they made that choice, it's probably because they had more identification evidence, or they thought they did, for Thomas Tracy. And of course the defendants lawyered up, and here we go. So the main lawyers on behalf of the state were Lloyd Black, who had only been practicing for a couple years, and H.D. Cooley, who was the city attorney. And H.D. Cooley had actually been on the dock at the time of the shooting. So he was a witness as well. He testified in the trial. Lloyd Black, I'll talk about his career some more, but he was in private practice and became special counsel and then a prosecuting attorney at this time of Snohomish County. He was by far the least seasoned attorney on the case. He gave the opening, the closing, and he ended up apologizing to the jury at the end for his lack of skill. Fred Moore, on the left, very famous socialist lawyer. He collaborated in many IWW trials. During this time, he was involved in the Los Angeles bombing case in 1911. There was a number of famous cases he was involved in. He was involved in the Centralia Massacre trial as well. He had very strong ideals. He was described as a friend with someone with no conscience once he decided his client was innocent, would stop at nothing, frame evidence, suborn witnesses. With friends like that, who needs enemies? But Fred Moore was brought in to really put part of this trial together, which was the publication of the IWW ideas. And on the right is George Vanderveer. As I told you, he graduated from Stanford and Columbia, made his way to Seattle. He was part of, I suppose you would call him the upper class in Seattle at the time. But and his world was of sort of upper middle class lawyers, social clubs, that kind of thing. But he was drawn by Skid Row and the people who began to frequent it. And unlike in Everett, Seattle had almost kind of two different complete neighborhoods downtown. Once you came south of what was called the Deadline in Seattle, which was about Yesler Way, into what was then called Pioneer Place, you ran into where the working men and women lived. There was a lot of soapbox oratory. The IWW were free to speak anywhere they wished there. And it was popular for a number of people who were more well-to-do to go slum tourism, to walk through this neighborhood, see the working men, the loggers, the sailors, the box houses. Are you familiar with that term, box houses? That was in Seattle, that was very famous. It was a way of having prostitutes where these theaters would have these boxes where they actually had beds inside of them so that the theater owner could disclaim any responsibility for the prostitution acts. Under Hiram Gill at the time of the Everett Massacre, Seattle was a wide open city. There was also prohibition had been passed by the state in 1914 in a limited fashion. You could import your own liquor from outside of the state, and you could get prescription liquor. So of course, there were some very prosperous pharmacists at the time, specifically the Billingsley brothers, and I'm telling you about them because they're going to figure into this trial. The Billingsley brothers were represented by George Vanderveer, and Hiram Gill was on their take. and Whoopi Whoppingstein, who was the police chief in Seattle at that time. You bought and sold your beat. It was wide open. Vanderveer was a big personality. He was a table pounder. He was an actor in court. He was quick-tempered. When he would go walk through the Pioneer Place area, if he ever got any guff from anyone, more than once he came home with a black eye. He would get in fights. He would not back down from anything. He held very strong opinions about the justice of his clients, both when he was a prosecutor and then when he became a defense attorney at this time. And this would kind of change his politics. But at this time, his politics are relatively mainstream. He had just finished time as a reform prosecutor, which meant he didn't believe in corruption. He had trying to root out corruption. And when Hiram Gill came in, he had lost that race, or that at the time. So later on, George Vanderveer would earn the reputation of counsel for the damned. He represented hundreds of working men for free who used to pack his offices, but that was all to come, and this trial changed him, as I said, but the IWW this time did not trust him. He was by far and away the best lawyer in this case. Fred Moore, unfortunately, was a cocaine addict, which came out later, and not entirely reliable. But Thomas Tracy had George Vanderveer. So the first thing that happened in this case was that they moved to recuse the judges up in Snohomish County, Judge Bell and Judge Alston. And I have the minutes here, which I don't think I'm going to go into in detail, but they moved as soon as they got on the case for a change of judge, saying that Judge Bell was prejudiced. Judge Bell denied the motion, but allowed them to move to the Supreme Court if they wished to. And then Judge Bell changed departments, changed his seat, swapped with another judge, which was sort of a face-saving way out. Then they got Judge Alston. They filed an affidavit of prejudice against Judge Alston, and Judge Alston called the governor. Judge Alston called the governor and said, I need you to appoint a judge to try this case that is not in Snohomish County. And the man that he appointed, here's the King County Courthouse at the time of the trial, by the way. It was just being constructed. It was brand new. It was 5 stories tall, 12 stories now, of course. There's a picturesque view with the postcard. Morrison. My great-grandfather ran a barbershop right here at this time. 5 chairs. He had gone to the Yukon Gold Rush and cut people's hair and saved enough money to start his own barbershop. James T. Ronald was the judge who presided over the case. He was appointed by the governor, probably also the most famous, historically the most famous judge out of King County. He had come to Seattle in 1882 with his wife and daughters, a young lawyer. He was involved in the formation of the King County Bar, which formed in part to response to the anti-Chinese riots as a way for lawyers to take a stand against what was going on with the prejudice. He was a deputy prosecuting attorney, mayor, and then he became a judge in 1909. So at this time, he had been working for about 8 years as a judge. And the first motion they made was a change of venue. And you'll excuse me if I use this large magnifying glass to read some of these pleadings. In their change of venue, some of the things that they talked about was the personal attitude of the people that the lawyers had met in Everett. And they said, well, they declined to discuss in any way with the undersigned, and in a few cases he went so far to inform the deponent, that's the person making it, that no decent lawyer would defend the defendants. And the deponent believes as a result of such interviews and investigation, there exists throughout the city of Everett and the county of Snohomish a widespread and general feeling of hostility and prejudice against the defendants herein. That motion was, yes?
You had said that the IWW asked the judge who he recommended for their attorney. Which of the judges was that?
Oh, Judge Donworth was the one who recommended George Vanderveer. Yeah. So, and another affidavit talks about how 95% of the business establishments said they could not be unprejudiced and were in fact bitterly hostile towards these defendants. The motion to change venue was granted. It went to King County. And let me just talk for a moment about the role of a judge. So as a judge, there's sort of two roles that a judge has, and this is important in explaining some of the decisions that were made. One of the roles a judge has is to make decisions, and that's obvious. But you have to make substantive decisions about what the law is, interpret the law, and sometimes render disputes. But another part that a judge has is to be an umpire, a referee. That's over the rules that are set down and how to let things come in fairly. This will come up with the introduction or the attempted introduction of IWW evidence during the trial. So, and let me just go a little further on that and talk about what a trial is. So a trial, as you may not have thought of it this way, but it's a recreation of events by people who are not at the event. It's a recreation by lawyers on behalf of their clients of this event in a way that will benefit their client. And lawyers tend to look at trials in terms of good facts and bad facts. And they try to amplify the good facts and explain the bad facts throughout their trials. This is their job, really. Now, as a prosecutor, they have a different role. They have an ethical duty to present all of the facts, but that doesn't prevent certain prosecutors from going over the line. I think you all know that or know of examples of that. So anyway, that's the role, and the judge has to make these kinds of decisions. So voir dire began, and this shows only men on the jury, but in fact, this is not a picture of the jury in this case. There were women on the jury for the Everett Massacre. But it was very different than today. Today, I have a trial that's been going on for about 6 weeks, and I keep telling the jury that you're not being seen by the television cameras because every day is televised on King 5, and and no one knows who you are. In those days, your name and address was published in the local paper. And you were sequestered the entire time. You were kept in a hotel, escorted by marshals, and you did have occasional entertainment by the judge. But again, I'm going to have to give you your indulgence here for a second while I attempt to read. So this is a typical voir dire. J.W. Etaw, 117 24th Avenue, a wholesale furniture manufacturer for 26 years, answered to the state's examination. He's an employer of labor, but he has no trouble in this case. He was passed by the state. So what's going on in the voir dire process is one at a time they're interviewing the various jurors who might be serving on this jury. And as they do, they're allowed to have a certain amount of peremptory challenges or challenges for cause. Challenges for cause have to do with prejudice. Peremptory challenges means you get to excuse somebody without giving a reason. Typically, you get 6 of those in a criminal trial. Challenge for cause might be, I can't possibly be fair to this defendant because I hold very different views than him. So in this particular case, he was interviewed, and he said, well, I am the president of the library board, and I've read a number of IWW works, but I haven't been influenced by them. Is it your feeling that you have such a character that would in any way affect the verdict if the evidence should develop that the defendant and his associates went to Everett for the purpose of maintaining the general program of the closed shop as endorsed by the labor union? And Mr. Etaw said he had an opinion on the closed shop. He explained in further examination that he employed about 15 men, and when the question of unionizing had been put up, he granted the request, and the 2 departments of work had been unionized. He was kept on the jury. Further down, there was another man who was interviewed. Have you any prejudice against the union laboring man? Asked Vanderveer. No, but if a man is working for me, and I would be the boss and my word would be the law. I think this much, if I hire a man and he didn't want to work, he don't have to work for me. It would just be the same if I employed 100 men. Do you believe in the right of laboring men to act in common? I believe if a man don't want to work for me, he don't have to. Do you believe in the rights of laboring men to persuade others not to work? I wouldn't have any free speech on the subject. Have you heard of the IWW? Yes. Do you have any opinion on their ideas? I think they step beyond the bounds. I don't think much of them as I ought, maybe. Are you governed by your opinions and believe in enforcing them? That's me exactly. He was recused. March 8, Mr. Lloyd Black begins his opening. Remember, he's the inexperienced one, but for whatever reason, he's kind of thrust to the front. Probably because Cooley, who'd been the city attorney, was an actual witness to the case and had been on the dock at the time of the shooting. So, prosecutor dwelled on the fact that there had been a eviction of 41 members of the IWW from Everett before the riot, and that he talked about the telegram, talked about the fact that they were calling for action, and they meant to basically start violence. And he will state that there'll be evidence that the first shots were fired from the Verona that killed Jefferson Beard, and they started the firefight. So the testimony begins. Excuse me, I'm used to a big bench where I can just spread my papers a little bit quick. And the first testimony is from Jefferson Beard's relatives and the coroner, establishing the fact of death, the fact that he died, and the cause of death. And after that, almost immediately, the case falls into what I'll call factual pandemonium. The reality was that George Vanderveer scored early and often as to the fact that there were so many different stories about what happened and so many different points of view in an event where there's 200 men on one side and a number of 100 men on a boat, and shots are fired almost immediately, and nobody exactly can say what happened. The main issue in the trial, oh, by the way, I need to show you something else here. So the state's case is that the IWW favored direct action and not the ballot for union formation, and that they were coming to incite a riot, and that Tracy could be identified and was a leader. This is the burden of proof. I'm sorry this is a little hard to read, but this is probably important for you to understand. Early on, the jury would not be told this till the end of the trial because they were instructed at the end of the trial. There were two facts necessary to convict this defendant: that some person on the boat, some person, unlawfully killed Jefferson Beard. Didn't have to be Thomas Tracy. And that this defendant aided, incited, or encouraged such shooting. In a word, conspiracy had to be proven. That was the burden that was taken by the state, and that was the burden really they had to assume, because nobody could possibly identify who had shot Jefferson Beard specifically. So, right off the bat, the first eyewitness is a man named Harry Shaw. And one of the big issues in the case is the sheriff walks up, he's got a gun on his hip, and he's talked to them. Who is your leader? So Harry Shaw testified that the sheriff raised his left hand when he did that with his hand on the gun. Owen Clay was the next witness. He testified the sheriff raised his right hand and left his left hand hanging at his side. W.P. Bell testified, he was a former prosecutor and Superior Court judge. He testified that both hands were raised. And he testified the first shot came from the boat. Owen Clay's testimony is somewhat legendary in this case. He was a bookkeeper for Weyerhaeuser. Like a lot of these men, deputized summarily and given guns out of the commercial club. A lot of the guns came from the armory, put into the commercial club, and taken from there to the dock. A lot of rifles, over 60 rifles were brought. A lot of people brought their own handguns. So they, as I say, there were a number of men inside the warehouse, and then they streamed out just as the Verona was pulling up. He said the noise from the men on the Verona was so loud that he couldn't really hear what was going on and couldn't be said. This is Owen Clay. He testified that shots were fired and he fired back. He testified that he kind of fired blindly into the boat with his revolver, unloaded it, was shot in the arm, went back into one of those warehouses that you saw, which is very close by, and then went around the corner and unloaded his gun again. And then he passed out from the loss of blood. So he was cross-examined by Vanderveer. You know what the purpose was for the deputies marching from the warehouses down to the dock? The purpose was to stop the men from landing. Well, did you see any of the men on the boat firing their guns? No. Anything wrong with your eyesight? No. Could you tell how many shots came from the boat? Well, I could tell from the sound some shots came from the boat. You may have heard a bunch of firecrackers. Was that how it sounded? Yes. When you pulled out your gun, did you shoot the captain? No. Did you hit anyone? I don't know. You knew there were hundreds hundreds of people shooting. I don't know that. I just heard bullets passing by me. And then he was asked about how he could shoot around the corner, and then these questions were asked. Remember, Jefferson Beard is the victim in this case. Who shot Jefferson Beard? I don't know. Did you shoot Jefferson Beard? I don't know. Vanderveer grinned and looked at the jury. Vanderveer was a big actor. He would have no problem walking up the jury box, walking away. He's very famous for doing that. He did that a number of times. Now I need to talk a little bit about the concept of other acts evidence. The audience here, there were 16 newspapers in attendance. Judge Ronald had a special desk built for the newspapermen to write. There were famous labor and socialist leaders that attended. But this trial was not always on the front page of the Seattle papers. The Billingsleys were on the front page of the Seattle papers at this time. They're the bootleggers that George Vanderveer had represented, still did represent. And at the time, the Billingsleys had said that they had testified in a federal trial that was going on, that they had paid off the mayor. That was one on the front page. All right, evidence makes strange bedfellows. There's this concept in trials that other acts evidence of other acts may or may not be completely related to the trial, can be admitted or not admitted. In this case, the prosecutor wanted all of the IWW evidence in. What had happened in Everett, of course, came in, the Beverly Park incident, some other acts. But they wanted to read about the Walker Smith's book, Sabotage. Have you guys heard about that? I'll show you the front of it. And they wanted to read some of the songs from the Joe Hill Memorial IWW songbook. They wanted a number of these things in to prove that the IWW was violent. Mr. Moore also wanted these admitted because he saw this as a trial to publicize the IWW ideas. Only Mr. Vanderveer wanted it out because he thought it was too prejudicial. He wanted to prove that the IWW was peaceful that day. So there was a little discontinuity here. And what Vanderveer knew, that juries wrestle with deciding the big societal issue versus the individual issue. This says, we find that all of us as society are to blame, but only the defendant is guilty. That was not the result that George Vanderveer wanted. He wanted to make sure that his client walked out of that courtroom a free man. So clearly the telegram, this is the telegram I read to you, was relevant, calling for IWW volunteers to come to Everett and fight. The Joe Hill Memorial edition of the IWW songbook did have some relevance. The IWW was singing songs on the way up on the Verona and the Callista to this demonstration. And there was much evidence about a number of the street demonstrations and speaking about this. And then there's Walker C. Smith's book, Sabotage. That was a very famous book. This is a book that that Vanderveer tried to keep out. But the state had it. And how did they have it? Because the men in jail mailed it to them. The IWW, people in jail and outside of jail, mailed them all of the pamphlets and books that have been published by the IWW with no return address because they wanted the state to introduce this stuff in the trial. So this stuff was all swamped in. This is just, I always have loved this graphic over here on the left. This is the IWW. Published, this is published in Spokane, by the way. Have you all ever seen this? The bottom says, we feed you all, we eat for you, we shoot at you, we fool you, we rule you. The capitalism system. Anyway, these are all things that were mailed to the jury. I'll get to that in 1 second here. All right, so the defense lost the motion, at least Vanderveer lost the motion, to keep out the evidence. And what Judge Ronald ruled was that, and remember, there's all this evidence about what happened at Beverly Park, what happened on the street at Hewitt Avenue, people being arrested, people being beaten. And the state wants to show that there is this incredible hostile feeling between the strikers and the men at work, and that this third party come up, these IWW workers come up who are not from Everett, and they're determined to stir trouble. They're not, the state argues, they're not there to settle any strikes. They don't have a stake in that. They're simply there to fight. And what Ronald ruled was, he said, well, suppose on the one hand, he and on the other hand, Mr. Vanderveer had bad blood between them, and one said the other was coming over, and they were both prepared to shoot. The question was who fired the first shot. He ruled it would be material to know the fight that had been going on between the two parties and the disputes that had been going on. There was also a PI article that was admitted to show the deputy's state of mind. The PI article talked about that there was going to be sabotage, and there was a question about whether the PI article was actually prompted by, I don't know if you all know this, there was a Pinkerton, two Pinkertons on the Verona who were posing as workers, and one of them arguably started or suggested that there'd be sabotage during one of the IWW meetings before they went up on the Verona. So all of this did come in. So they introduced the IWW telegram, the pamphlet Sabotage by Walker C. Smith. They read out loud the songs, some of the songs, including, this is my favorite one, I'll be brief. The Sabo Tabby Kitty. So the kitten called Sabo represented sabotage for the IWW. And you rotten rats, go hide your faces. I'm right here, so hunt your places. Hurry now. Wonder how? Meow. Sabotage. The tiger wild in the jungle sitting. Never fights like this here kitten. Hurry now. Wonder how? Meow. Sabotage. Poem goes on for a long time. And apparently Thomas Tracy laughed out loud when the poem was written. Excuse me. All right, on March 16th, Mayor Merrill was called, and the mayor of Everett was called to talk about all the troubles caused by the IWW. And in another famous cross-examination moment, after talking about the fact that the IWW had caused violence, had contravened the law of Everett, he said that they had also caused arson, $100,000 worth of arson. And they had the fire department report on that, and that was way out of proportion to whatever happened, and he knew it was the IWW. Whereupon Vanderveer produced the report, and it showed losses of $21,000, consistent with past years. And when he was asked where he got the larger figure, he said, well, it may have been from losses in mills outside the city. But Vanderveer had made his point. On March 19th, the trial was temporarily interrupted. See the headline, Billingsley said he bribed Gill. There's a cartoon at the time of Hiram Gill, civic indecency, open gambling, thuggery, graft, and Whoppy. Whoppy is the police chief. And there was a recall election. Look at the very top there. Witness names Vanderveer. Logan Billingsley had named Vanderveer, and Vanderveer had to stop the trial so that Vanderveer could go testify about his role or lack of role. In the end of that trial, the decision maker, which is the judge, I believe, in this particular case, decided that Billingsley was a liar. And all of the people went forward. Actually, this case destroyed Hiram Gill's career for a few years, and then Hiram Gill, having been the wide open mayor, ran as a reform mayor a number of years later. So there's a lot to this trial, and I think I'm going to try and summarize some of this. I hope I haven't skipped anything that people wanted to hear about. But there were many witnesses who testified that they had seen many rifles in the commercial club. I think I've talked about that. The Beverly Park story was told in great detail, as was a lot of the events that occurred in Everett before the Verona. There was testimony that multiple IWW individuals have been trying to cause problems, and the engineer, as I told you, from the Verona testified. He testified that he's put his face out the window. The engine room was below the main deck. He received an eye full of red pepper, so he looked for a safe spot. A whole bunch of people jumped down into the engine pit who were looking for cover from the rifle shots, and one man begged him to pull out. He put it in reverse, and that's what caused the boat to swing from being parallel with the dock to perpendicular with the dock, held by a line. So by March 23rd, the trial had been going on, and they had been repeating the same events over and over again. Judge Ronald called counsel and told them to stop repeating themselves. that the witnesses, the jury was getting tired, and so they started shortening the trial. Now, the other main evidence that Vanderveer cross-examined on, March 27th, Sheriff McRae testified that he had seen Thomas Tracy firing out of the side window. He testified that he knew him, he identified him. A number of other people said the same thing. A deputy named William Bridge testified that he could see him out of the second and third window from the back. But then he was cross-examined with his coroner testimony, which was taken the day after, where he said, well, actually, no, he couldn't see Thomas Tracy at all. Walter Smith, a deputy who was a shingle worker, scab, misidentified Tracy and another man with a picture. Vanderveer said, is this the man you said was Thomas Tracy? Yes. Wait. Too late. And he showed the jury, and it was not Thomas Tracy. And finally, Vanderveer was able to show that the boat, because of its position, kind of out like this from the dock, you could not see the side windows. And where the people were on the dock, they could not possibly have seen anyone in a side window, as they said they saw Thomas Tracy. The state rests, and Thomas Tracy turned to his lawyers and said, and I quote, as far as I'm concerned, you can let the case go to the jury right now. And he was right. But that was not what the IWW wanted. So the defense case started on April 2nd, and two major events occurred that day. Fred Moore opened. He talked about how the mills, the banks, and the hardware stores relied on the commercial club, and they controlled the sheriff. They noted the violence in the earlier shingle weaver strikes before the IWW came in, and talked about how there was a lot of violence that had occurred, including the Beverly Park incident. And when the Verona landed, met by McRae and many hostile men, they fired first. The second event that occurred, and this is just when the IWW is hoping to publicize their ideas, is that Wilson appeared in front of Congress and asked them to declare war against Germany. And because of that event, all the headlines of this trial went off the front page. And the IWW people testified, but they were not publicizing their ideas as they had wished. Herbert Mahler was the Seattle secretary of the IWW. He testified about the events that occurred and a lot about some of the beliefs of the IWW. He was cross-examined about the Joe Hill Memorial Songbook and why Joe Hill stood for a murder charge. As you may know, Joe Hill stood for a murder charge because he got in a fight over a woman. Had nothing to do with the IWW at all, in fact, although he's very famous, obviously, for labor reasons. And then James Thompson testified, who's one of the charter members of the IWW and a national organizer. And he, as George W. Bush might have said, speechified quite a bit. He said, if we break any laws, it is the duty of the officers to arrest us, but the officers should be sure that we have violated a law, and we should, under the law, be presumed innocent, and punishment shouldn't be meted out according to the view of a drunken sheriff. Vanderveer had asked many questions about whether or not the sheriff appeared drunk on the day in question. And Thompson was asked, is there no such thing as patriotism according to the IWW? And he said, the IWW believes in dividing people into groups is wrong. Pride in the nation is a cause of war today, and international solidarity is the answer to that. On April 7th, the headline of the trial is as follows: Tracy jurors guess of Judge Ronald at the moving picture show. And this is a rather prejudiced view of the trial, but during the last week, the case has lost what little atmosphere of a murder trial it held during the first few weeks. Both sides have gone deeply into the IWW doctrines and ideas, with the result that the actual shooting and killing at the Everett dock has been left in the background. The advocates for the IWW and almost every modern ism have begun to flock to the court. Throughout this case, representatives of the IWW, socialists, AFL, anarchists, agnostics, atheists, freethinkers, materialists, idealists, non-Malthusians, single taxers, pacifists, imaginists, theosophists, and it's even been said that vegetarians have been seen. A juror's life sequestered. So I'm going to talk about this a little bit. I'm going to go into the closing argument, and then I'm going to tell you about the aftermath of the trial here. So in those days, to create a record, if the judge had a question, he would write on a piece of paper, and he would have his clerk pass it to the lawyers to sign off that they had read it. So this one says, do you have any objection to, I can't remember her name, I didn't bring the jury list with me, but a woman on the jury speak a few words, or it's a man on the jury, speak a few words with his wife this evening. And then they had to okay it. So there's their initials, Vanderveer, Black. This is the note asking if he can take the jurors to the movies. And then he also the judge celebrated his birthday with the jurors. And back in the right corner, you can see the approval by the lawyers. And then this is Judge Ronald's house, actually, many years later, obviously. It said, if it is suitable weather and both sides perfectly willing, the jury may come to meet my house this evening and hear some music and entertains. There will be no one there except my wife and possibly a daughter. Express yourselves freely. If it makes any difference, makes no difference to me. And then Black says yes, and Vanderveer, for the defense, approved it. He says, as long as the music is not patriotic. So the judge agreed. During the defense case, as you know, Cooley was a witness to what actually happened, one of the lawyers in the prosecution side. And Vanderveer pulled one of his famous stunts during that time. He called Cooley to the stand and stood in front of him like this, like a wrestler, and said, "By who are you employed?" And immediately the state objected. Well, of course, the answer was by Snohomish County. But the objection, and he looked at the jury, and the inference was he's employed by the commercial club. And so Cooley got off the stand, and that was the end of that. That's the kind of stunt that Vanderveer did all the time. So evidence was brought out that the Everett Commercial Club was trying to make the Everett an open shop town, that there had been speeches to the deputies about becoming an open shop. There was questions to the mill owners about whether they paid the sheriff. And the defense called two former deputies to testify that McRae, the sheriff, had actually been the one who organized the Beverly Park incident, the running down the gauntlet. There were young boys who testified that they had gone to the scene afterwards and collected shells. That evidence came in to try and prove the number of bullets that had been fired. Over and over, Vanderveer attempted to argue during the trial that free speech was a central issue. But Ronald sustained objections to those questions, noticing the issue was what happened at the dock. And I think for Ronald, it was a very difficult case to kind of keep his hands around, as so much was coming in, and there was a lot of testimony about a lot of different things. The defense also called an engineer, F.H. Whitworth, Jr., who testified there had been 189 pistol and rifle bullets through the boat alone. 189. And he testified there were over 50 shots fired from inside the warehouse. So unless you're unclear about this, imagine this. The Verona's pulling up. These three men are in front. And just as the Verona's pulling up, all these sheriff deputies come out. And the shooting starts, and they all scatter. Some go flat, some fire where they're standing, some run inside, and some apparently fired through the wall of the warehouses where they thought the ship might have been, without even looking. I talked to you about Lloyd Black, and unfortunately he became kind of an issue. He was very young, he's very new. Walter Smith, who wrote the book Sabotage, also wrote a book about the Everett Massacre. He described Black as an idiot. And on one point he cross-examined, and he said to a defense witness, well, on the Verona, what were you talking about or not talking about? And Judge Ronald piped up, well, there could have been 2 or 3 million things they were not talking about. It's never a good way to get a sarcastic comment from the judge. At another point, he was cross-examining a witness named Collins, who had been at IWW member who was on the Verona came back, and he was picking up cartridges or shells. On the way back on the Verona, the members picked up cartridges they could find on the ship, and they threw them overboard. They also threw all their guns overboard. But they testified about it. Nobody denied it had happened. They threw them all overboard. And Collins was trying to get him to admit that he found a certain number of cartridges or shells because he's trying to show that these cartridges are released and trying to prove the number of bullets that the IWW is firing at the dock. And he said, "Didn't you pick up anything from the deck?" And Collins said, "I picked up an eye, a man's eye." Finally, Thomas Tracy testified. Vanderveer called character witnesses on behalf of Thomas Tracy to say he was a man of good character, and Tracy denied firing the shot that killed Beard and was unarmed. And if I didn't tell you this, I'm trying to move through this a little bit, but Sheriff McCrae testified, was cross-examined pretty hard by Vanderveer, but stuck to his story. So, in closing argument, I wanted to read a couple of the instructions, which I think you will find very interesting. And then I'm going to talk to you about the closing and the aftermath of the trial. I think it's not a mystery to you all what the, excuse me a second here. I've got them right here. It's not a mystery to you what the verdict was. As I told you, they had to prove a conspiracy in this case, the state. They had to prove that some person on the boat unlawfully killed Jefferson Beard and that the defendant aided, incited, or encouraged such shooting. But the court commented on the evidence quite a bit. They talked a lot about the earlier events in Everett. He said, now whether any of the industrial workers of the world had been, prior to November 5th, 1916, guilty of encouraging disrespect for the law or of unlawful assembly or of riot is not the question on trial here. They could all be guilty of all acts or all offenses herefore mentioned, and this defendant could still be innocent of the particular crime charged on November 5th, or they could all be innocent of the acts mentioned, and the defendant could still be guilty of the main charge. And he read the same instruction about the sheriff. He talked about self-defense. He said, a person may have a lively apprehension that he is in imminent danger and believe his apprehension is based on sufficient cause and supported by reasonable grounds. If, however, he acts on these appearances, he does so at his own peril, because the law leaves it to no person to be, no man, excuse me, to be the exclusive judge of the reasonableness of the appearance on which he acts, but prescribes a standard of his own. That is, the person acting on appearances believe himself to be in deadly peril of his life, and would a reasonable man, situated as the slayer was, believing what he knew and seeing what he saw, be justified in believing himself to be in danger. And finally, he said, you must not allow yourself to be led to convict the defendant merely because he is a member of the industrial workers of the world, or merely because you believe that members of the organization have been guilty of defying lawful authorities, or merely because you find in the comparison the industrial workers of the world have been guilty of more lawlessness than the authorities and deserve greater condemnation, or of fear that a crime may go unavenged, or of the purpose of deterring others from the commission of a like offense. On the other hand, you may not acquit him merely because you believe that the authorities have been guilty of lawlessness towards the members of this organization and have escaped punishment therefore. So let me move to closing and the verdict. Mr. Black apologized in his closing for his incompetence, which is probably the first time I've ever heard of that before. He argued that the intent of the IWW was shown in their telegram and their literature was violent, and these people did not come to Everett on the Verona on November 5th for a peaceful purpose, but they came as revenge for wrongs they believed had been committed against them. He said, quote, no one comes for a peaceful purpose with revolvers in their pockets. George Vanderveer, he gave closing argument for the IWW. We have every confidence in the justice of our case. The state said it would prove a conspiracy of the organization by which the defendant member is set up as anarchy in Everett, and the state should apologize. If the IWW planned to commit murder on that day, why did they take the greatest pains for widespread publicity and invite representatives of the press? We don't deny that many in the boat wouldn't stand for the abuses that have been perpetrated. And then he said this, My opinion is if the IWW did shoot Sheriff McRae in the heel, he was shot in the heel, it was his belief, the shooter, that his brains were there. It is the greatest kindness I can do to McRae that he's a perjurer and deliberately and cold-bloodedly, anytime his conduct was in question. The court has said that it's not a question of who fired the first shot, this is Vanderveer, but who made the first aggressive action. It was McRae who pulled his gun before a shot was fired. The leopard cannot change his spots, and you have to take into consideration who were the aggressors in the past. Did you ever in your life, he said, hear of deputy sheriffs taking instructions from a commercial club and being instructed in the doctrine of open shop? If the sheriff did not intend trouble, why did he keep his men hidden in the warehouse until the last minute? And why did he tell the boat that they must not dock? In my opinion, he intended to teach them a lesson. And he ended with this. He read from a Federal Industrials Relations report. And this shows the changing of evolution of George Vanderveer. 2% own 65% of the wealth in this nation, and 65% own 5% of the wealth. The rights of the working men are at stake in this case. These are the instructions that I read to you. And there is the verdict. Not guilty. So, this was the longest trial in the history of King County at the time. 150 witnesses, many who were called more than once. The jurors took 22 ballots, starting with 4 guilty, 8 not guilty. And right after Thomas Tracy was acquitted, all the other 73 men were released. It cost $35,000, a huge sum at that time. And here's a little bit about the people who served. Judge Ronald served as a judge until he was 94 years old, which is actually not, you can't do that anymore. He served in many prominent trials, including a very famous murder case involving a bootlegger called the Trunk Murder case that occurred in the 20s. Fred Moore represented the IWW and actually represented Sacco in the Sacco-Vanzetti trials. And Sacco was of the opinion that he was completely incompetent. And sadly at the time, Moore was deep in the throes of his cocaine addiction, and his son later reported that he had to be brought cocaine every day just to survive. George Vanderveer became a changed man. He represented hundreds of workmen for free. In 1918, he represented Big Bill Haywood in Chicago. He later represented the most famous bootlegger in Northwest history, Roy Olmsted, in a trial in the 20s. He lost that trial, but he set a precedent. It was a trial where the prohibition agents tapped the phones of everyone involved without a court order, and the Supreme Court upheld it at the time, and later Congress passed an act to prohibit such wiretapping. I couldn't find anything that happened to Thomas Tracy. I have intimated, and it's true that the IWW somewhat faded because of the declaration of war, but as you probably know, Seattle was the location of the first general strike in the history of the United States in 1919. Kind of a legacy of what had happened with the IWW. And you've probably seen this, published after what had happened during the time of the